Sexual harassment in the workplace has been a persistent problem that has damaged lives, careers and organisations. It can take various forms such as inappropriate jokes or comments, unwanted physical advances, the dissemination of sexually explicit materials, and sexual assault. Unfortunately, individuals who experience sexual harassment at work frequently face obstacles to coming forward, including the fear of retaliation, embarrassment, and the belief that their employer will not take them seriously. As a result, a pervasive culture of tolerance for sexual harassment has developed in some workplaces, with many individuals enduring such behaviour without taking any action. To address the problem, the Australian Human Rights Commission published a report that made 55 policy and legislative suggestions for preventing and addressing sexual harassment in both the public and private sectors. In December 2022, important changes to the Sex Discrimination Act 1984 came into effect, along with legislation that amended the Fair Work Act 2009. The objective of implementing these crucial changes together is to address and alleviate the issue of sexual harassment in the workplace. Hi, I'm Lucinda Frantz, a senior solicitor at WilliamsonBarwick, an employment and industrial law firm. Join me as I run through your new obligations as an employer in terms of the Respect at Work and Fair Work Act reforms and what steps you must take to ensure compliance. The first significant change is that under the Fair Work Act, it's now unlawful for a person to subject a fellow worker to sexual harassment in relation to their work. The prohibition applies from 6 April 2023 to workers, potential workers, and people doing business, and includes employees, volunteers and contractors. And if a sexual harassment dispute arises, a worker or workers jointly or their union can apply to the Fair Work Commission to make a stop sexual harassment order or to resolve the dispute. If the Commission can't resolve the dispute, it will issue a certificate, allowing a party to take further action in court. The next significant change is the positive duty that now rests on employers to eliminate sexual harassment in the workplace. This new requirement under the Sex Discrimination Act aims to shift the employer's focus from reacting to conduct that has already happened to taking preventative measures to avoid such behaviour occurring. In other words, the positive duty requires employers to now take all reasonable and appropriate actions to prevent and address workplace harassment. The Sex Discrimination Act now also expressly prohibits a person from subjecting another person to a work environment that is hostile on the ground of sex, which can take many forms, including witnessing another person who's making sexual jokes or comments, displaying sexually explicit material in the workplace, making threats or spreading rumours based on a person's sex or sexual orientation, singling out individuals for unfair treatment or exclusion based on their sex. The test is whether, taking into account all the circumstances, the behaviour is likely to be seen as resulting in a workplace environment that is offensive, intimidating or humiliating based on a person's sex. This involves considering the seriousness of the conduct, whether the conduct was continuous or repetitive, and the seniority of the person engaging in the conduct. Where an employer can't show that they took all reasonable steps to prevent a hostile workplace environment, they'll be held vicariously liable for the unlawful conduct of the employee or agent who engaged in the sexually harassing behaviour. Another key reform is to the Australian Human Rights Commission Act to give the Australian Human Rights Commission stronger investigative and enforcement abilities to ensure employers comply with the positive duty I spoke about at the start of the video. With these new powers, the AHRC can investigate employers' compliance with the positive duty, provide suggestions to employers to prevent continued non-compliance, issue a compliance notice that specifies what actions employers must take to address their non-compliance, apply to the federal courts to enforce a compliance notice, enter into an enforceable undertaking with an employer to ensure their compliance. The AHRC's new compliance powers come into effect in December 2023 to give employers time to become familiar with the positive duty and start complying. Another noteworthy reform is the introduction of a lower threshold to the test for finding sexual harassment in the workplace. Before, the nature of the behaviour had to be unwelcome conduct of a seriously demeaning nature. Now it just needs to be unwelcome conduct of a demeaning nature, making it easier to prove that sexual harassment has occurred. Since the new positive duty requirements already apply, organisations must take immediate steps to comply with the positive duty to eliminate sexual harassment in the workplace. Organisations should consider taking the following steps if they haven't already. Number 1, review policies and procedures related to sexual discrimination and sexual harassment to ensure they follow the new laws. Number 2, provide staff with training on sex discrimination and sexual harassment. Number 3, train managers and supervisors on how to deal with claims and complaints about discrimination and harassment. Number 4, conduct a work health and safety risk assessment to identify and address hazards related to discrimination and harassment. This might include considering the workplace gender composition, analysing gendered trends and reviewing work travel requirements. Number 5, evaluate the support services available to employees who experience sexual harassment. I hope you find this video valuable. But if you need help understanding your new obligations or want to talk to one of our lawyers about the changes and what they mean for your workplace, please reach out to us. We're here to help you navigate these changes and take the necessary steps to ensure your workplace complies with the new laws.